All right, Wednesday, federal judge unsealed something big. Trump's encrypted messages, Signal, WhatsApp, Telegram, 847 communications. Court documents just dropped. According to official filings, these aren't public statements. These are private conversations Trump thought stayed private. I've been going through the 73-page order. Here's what I found. The judge didn't just order disclosure, called the encryption deliberate circumvention of record-keeping laws. That's not my interpretation. That's page 4, paragraph 11. You saw the headlines. Here's what they missed. Quick context. Donald Trump, former president, currently facing multiple federal investigations. The issue, prosecutors argued he used encrypted apps specifically to avoid leaving evidence trails in official channels. Timeline, fast version. Months back, investigators noticed gaps in communication records during key periods. Weeks later, subpoenaed phone records showed encrypted app installations on dates matching those gaps. Wednesday, Judge Patricia Harmon ruled those messages aren't protected by any executive privilege claim. That's the setup. Now the documents. What makes this different from other Trump legal stories? This isn't about what he said publicly. It's about what he said when he thought nobody was watching. The government's not alleging these conversations happened. They have metadata proving it. Installation dates, active user logs, message counts. Trump's team fought disclosure for 7 months, lost Wednesday. Now the messages go to prosecutors. Okay, the evidence. First document, filed Wednesday morning. I pulled page 23. It says, quoting here, defendant installed Signal encrypted messaging application on 3 separate devices within 48 hours of receiving congressional subpoena notification. That's not my take. That's the filing. What it means? Trump downloaded encryption apps right after learning investigators wanted his communications. But here's what got me. Page 47, different section. Forensic analysis shows 312 messages sent between 11:47 p.m., June 28th, and 6:23 a.m., June 29th, last year. Single night, over 300 encrypted messages. Put those together, yeah, timing's not great. I went through this 4 times. Patterns clear. Subpoena arrives, encryption apps installed, communication volume spikes, then goes silent. All documented. Now, what nobody's covering. The recipients list includes 14 individuals who were simultaneously under separate federal investigation. Page 51, Exhibit G. Read that again. That changes this. Not just private conversations. Coordinated communication with people who had legal exposure. Judge Harmon specifically noted the synchronization of encrypted app adoption among multiple subjects suggests coordinated evasion rather than privacy preference. Fallout? Prosecutors now have legal authority to compel app companies to provide whatever message recovery is technically possible. Trump's legal team has to produce devices for forensic imaging within 11 days. Any messages recovered become admissible evidence across all pending federal cases. Within 72 hours of the ruling, but there's a technical problem prosecutors face. Signal uses end-to-end encryption. If messages were set to auto-delete, which the filing suggests they were, there may be nothing to recover. The government's argument hinges on metadata and usage patterns. Page 34 shows something interesting. Trump's primary device had Signal configured with 7-day message disappearance. But one of the other devices, a tablet registered to his business, had that feature disabled for 19 days before being turned on, meaning there's a 19-day window where messages might still exist. The filing includes screenshots from Apple's cloud backup showing partial Signal database files from June 12th through June 30th last year. Government forensics experts testified they could potentially reconstruct 40 to 60% of messages from that period. Former digital forensics supervisor at FBI, 27 years experience, told the court, modern encryption creates challenges, but device backups often preserve data users believe they've deleted. Translation: even encrypted apps leave traces if you know where to look. What the judge focused on wasn't whether messages still exist. It was whether using encryption to avoid record keeping violated the law. Her ruling: yes. That's just the first document. I'm breaking down the full 73 pages plus exhibits. Subscribe to this story has layers. Most coverage isn't touching. More coming on this. Okay, but look, gotta be fair here. The other side has a point. Few points, actually. Trump's legal team and constitutional scholars are saying this is massive First Amendment overreach. And honestly, some of it holds up. Their argument: private citizens, including former presidents, have constitutional rights to private communication. Using encrypted apps isn't illegal. It's recommended by cybersecurity experts for anyone handling sensitive information. Constitutional law professor at Georgetown, 31 years teaching Fourth Amendment law, put it this way: encryption is speech. Compelling decryption is compelled speech. That's a constitutional problem. Don't agree with all of it, but that's not nothing. What they've got? No law explicitly prohibits former presidents from using encrypted messaging. Presidential Records Act has gaps regarding personal devices and post-presidency communication. Even the ACLU filed an amicus brief expressing concern about the precedent. Their worry: if courts can compel decryption for Trump, that power extends to journalists, activists, and ordinary citizens. Backdoor access to encryption doesn't discriminate based on whose privacy it invades. That's their quote. Short version: this affects everyone, not just Trump. Look, I'm not here to tell you who's right. Prosecution's interpretation, evidence of deliberate evasion, supports it. Defense interpretation, privacy rights protect it. Both can be true. That's what makes this complicated. The defense also points out something legitimate. Trump received credible death threats throughout and after his presidency. Secret Service recommended encrypted communication for safety. There's documentation of that. So the question becomes, when does reasonable security become illegal evasion? Trump's attorneys argue prosecutors are criminalizing standard protective measures. Filing from his defense teams submitted Monday shows 11 other former senior officials who used similar encryption. None faced legal consequences. Why Trump? Defense says it's selective prosecution. Federal prosecutors counter that none of those officials were under active investigation at the time they adopted encryption. Timing matters. Defense: privacy is privacy regardless of timing. Prosecution: timing reveals intent. Judge sided with prosecution Wednesday, but acknowledged in her ruling, this case presents novel questions at the intersection of encryption technology, executive privilege, and criminal procedure. Even she admits this isn't clear-cut. What I can tell you, what the documents show, and they show Trump adopted encryption immediately after learning of investigative interest. Whether that's smart security or illegal evasion, that's what this case will determine. This didn't come out of nowhere. Backstory, quick. 2 years back, first reports surfaced about communication gaps during January 6th investigations. Congressional committees couldn't find records of calls Trump reportedly made that day. Year and a half back, House committee issued subpoenas for phone records. Carriers provided call logs showing dozens of conversations, but only with phone numbers, no content. Several numbers traced to encrypted app services. Year back, federal investigators opened separate inquiry into record-keeping practices. Presidential Records Act requires preserving official communications. Someone from the National Archives even said, on record, we identified substantial gaps inconsistent with known activity timelines. What happened? Trump's team argued private device communications aren't official records. Pattern emerged: investigation announcement, encryption app adoption, communication volume shifts to encrypted channels, official channels go quiet. Every time, legally ambiguous until Wednesday. Judge Harman's ruling changes the framework. She determined that when a former president is under investigation, the use of encryption to avoid producing records becomes obstruction. Not just privacy, active evasion. That's new legal ground. First ruling of its kind, applying record-keeping laws to encrypted messaging by a former executive. See where this is going? This isn't just about Trump. It's about what technology does to accountability. Like this if that angle matters to you. Wednesday, 2:17 p.m. Eastern. Here's what happened. Judge Harman issued her ruling from the bench. The court finds defendants' encryption adoption patterns constitute willful evasion of legitimate investigative process. Courtroom went silent. What followed? Trump's lead attorney requested immediate stay pending appeal. Denied. 11-day compliance deadline set. 47 minutes. That fast. Now, what everyone missed. While people focused on the encryption ruling, something else happened in that courtroom. Prosecutors revealed they'd already obtained cooperation from one of the 14 encrypted message recipients, then submitted under seal the content of 23 messages that person had screenshotted before deletion. Judge reviewed those in camera. Her response? Expedited the evidence production timeline. Wasn't reactive, calculated. You can see it in the ruling's footnote 7. Having reviewed samples provided by cooperating witness, the court finds probable cause that additional encrypted communications contain material evidence. She'd already seen some messages. That's why she rejected every defense motion. This is where it gets interesting. The prosecution didn't just argue Trump used encryption. They showed the judge actual message content proving why they needed the rest. We don't know what those 23 messages said, still sealed. But whatever they contained convinced a federal judge to override every privacy and executive privilege claim Trump's team made. Former Assistant U.S. Attorney, 19 years prosecuting public corruption, said after the hearing, "Judges don't expedite timelines unless sealed evidence is compelling. This tells you what prosecutors have." The public sees the encryption fight. Prosecutors are already past that. They've got cooperating witnesses, screenshots, and now court authority to get everything else. Don't go anywhere. What I show next changes how you think about this. Drop your prediction below. What do you think those 23 messages said? Then keep watching. What are experts saying? Former chief of DOJ Computer Crime Section, 14 years handling digital evidence. This ruling creates precedent. Encryption is no longer absolute shield against legal process. Plain English, courts can now order encryption broken if there's evidence of criminal intent. Another one. Cybersecurity law professor at Stanford. We've entered uncharted territory where privacy tools become evidence of consciousness of guilt. Key there, the tool itself isn't illegal, but how and when you use it matters. Here's what's interesting. Even Trump's own former White House counsel, who left before the investigations, admits best practice was always assume everything could become public record someday. When both sides agree, pay attention. Former presidents don't get the same privacy regular citizens do, at least not when official duties and personal activities overlap. Consensus among legal analysts: encryption alone isn't criminal. Timing and pattern can establish intent. Former officials have reduced privacy expectations around official period activities. That's where professionals land. The technical experts have different concerns. Chief Technology Officer at Electronic Frontier Foundation. Any backdoor mechanism created for law enforcement creates vulnerability exploitable by adversaries. They're not defending Trump specifically. They're worried about the broader implications. If courts can compel Apple or Signal to help recover deleted messages, who else gets that power? Foreign governments? Civil litigants? Divorce lawyers? Former NSA technical director, 23 years in signals intelligence. You cannot create selective access. Either encryption is secure for everyone or no one. Two separate debates happening. Legal, did Trump break the law? Technical, should courts have this power? Both matter, both complicated. Useful breakdown so far? That like button actually helps the algorithm show this to people who need context beyond headlines. Use it. Why should you care? Real talk, how this affects actual people. Privacy. If you use Signal, WhatsApp, Telegram, pay attention. What you thought was encrypted and private might be accessible if you're ever involved in litigation. Your employer, divorce proceedings, any civil lawsuit. This ruling establishes that encryption doesn't prevent court-ordered disclosure. Numbers. 2.4 billion people use encrypted messaging apps globally. Your privacy just got legally weaker. What's some people doing? Reviewing retention settings, being more careful what they write. Not advice, just what I'm seeing. Precedent. This sets a precedent. Next time you're in any legal situation, prosecutors can argue your use of encryption shows consciousness of guilt. Quick example. You're in a business dispute. Other side discovers you switched to encrypted apps after the conflict started. Not dramatic, but that timing can now be used against you in court. That's how this works now. Who's affected? Right now, anyone in federal investigation who uses encrypted communication. Prosecutors are already citing Wednesday's ruling in 3 separate cases. Affects everyone from corporate executives to activists. Hits differently depending on who you are. What nobody wants to say, uncomfortable part, privacy versus accountability, is a real trade-off. If you care about holding powerful people accountable, this ruling helps. If you care about protecting privacy from government overreach, this ruling hurts. If you're a regular person who values both things, you're part of this tension. Not trying to scare you, that's what legal scholars are saying. Practical, what informed people doing? Reviewing what they put in writing on any platform. Understanding encryption protects from hackers, not from courts. Asking lawyers whether communication is actually privileged before assuming it is. Knowledge helps. One more thing. If you ever serve in public office, any level, assume nothing is permanently private. Local school board, state legislature, federal appointment. Your encrypted messages from that period can potentially be subpoenaed years later. That's the world after Wednesday. The line between personal and public communication just got blurrier. For Trump, that's his current legal problem. For anyone who might serve publicly someday, that's your future consideration. Technology moves faster than law. Courts are catching up. Your privacy expectations should adjust accordingly. How'd Trump respond? Made it worse. Honestly, posted on Truth Social within 3 hours of the ruling, quote, "Corrupt judge violates my rights. Political persecution. This is what happens in communist countries." Reaction from legal experts? Calling a federal judge corrupt while you have pending cases before other federal judges isn't strategic? Could influence other judges' willingness to show leniency? Former federal judge served 31 years. Told CNN, defendants rarely benefit from attacking the judiciary during active litigation. Trump's attorneys came back with something different, filed notice of appeal Thursday morning, requesting stay from circuit court. Different tone, professional, focused on constitutional questions. Then Trump posted again Thursday afternoon. They want to see everything. I have nothing to hide. Let them look. Which directly contradicts his lawyer's arguments about privacy rights. His legal team reportedly frustrated. You can't simultaneously claim executive privilege and say you have nothing to hide. Those positions conflict. Defense attorneys prefer clients stay quiet. Trump's not wired that way. Not cooling down, heating up. Every post creates new problems. What's still unclear? 1. whether any messages are actually recoverable from signals encryption. 2, what those 23 cooperating witness screenshots contain, still sealed, could stay sealed through trial. Coming, Circuit Court has Trump's emergency stay request scheduled for oral arguments Tuesday, July 7th. 3-judge panel, Trump's team reportedly preparing constitutional challenge, Justice Department filing opposition brief Monday, date to watch Tuesday, July 14th. That's when the 11-day device production deadline hits. If Circuit Court doesn't grant a stay by then, Trump has to turn over phones and tablets. Forensic imaging happens that day. Also coming, prosecutors indicated they have 3 additional cooperating witnesses ready to provide testimony, haven't revealed who yet. July 8th, government's deadline to file witness list for the broader case. We'll know then, should know more by mid-month. Either Trump complies, appeals succeed, or we're in contempt territory. None of those are small developments. Clock's running. Subscribe. When that Circuit Court ruling drops or the deadline hits, I'll break down what it means. Stories moving fast. Notifications on. Where we are right now. Wednesday's ruling stands. No stay yet. Trump's devices must be produced by July 14th unless Circuit Court intervenes. 847 encrypted communications are subject to whatever recovery is technically possible. 23 messages already in prosecution's hands under seal. Multiple cooperating witnesses confirmed. Scheduled Tuesday, July 7th, Circuit Court oral arguments on emergency stay. Monday, July 6th, DOJ opposition brief due. Tuesday, July 14th, device production deadline. Wednesday, July 8th, witness list deadline. Not public yet, content of those cooperating witness screenshots. That's what everyone wants to know. Judge has seen them, prosecutors have them, defense will get them during discovery. Public might not see them until trial, if there is a trial. Sometimes once defendants see what prosecutors actually have, plea discussions start. Not speculation, just how federal cases often work. We're in the window where Trump's attorneys are assessing actual exposure versus what they thought exposure was. Clock's running, that's where we are. Trump fighting a federal ruling that gives prosecutors access to messages he thought were encrypted and gone. Surface read, another legal battle in a long list. But this one's different because it's not about what Trump said publicly. It's about what he said privately when he thought there'd be no record. Those are the conversations that usually matter most in criminal cases. The constitutional questions here are real. Privacy versus accountability, encryption versus transparency. No easy answers. I'll be watching whether Circuit Court sees this as executive privilege issue or obstruction issue. That framing determines everything. Story's not over, still developing. When Tuesday's oral arguments happen, I'll break down what each side argues and what the judge's questions reveal. When July 14th hits, compliance or contempt, we'll cover what happens. Subscribe for the full picture, not just the headlines screaming about encryption. When those sealed documents eventually surface, you'll want the context. Talk soon.